Well, good morning. Welcome back to those who also attended the AGM. It is my very great pleasure to introduce our speaker this morning. Our speaker is Cynthia J. Neville. She's accompanied by her husband. We're grateful that he's also come to join us today as well. Professor Neville is Professor Emeritus in the Department of History at Dalhousie University in Halifax in Canada, and also Adjunct Professor in the Department of History and the Centre for Scottish Studies in the University of Guelph, also in Canada. She has published extensively on the subject of Gaelic lordship and society in later medieval Scotland, and particularly on the impact of an Anglo-Norman and European ideas on the culture of the Gaelic peoples of Scotland in the 12th and 13th centuries. She's published widely. I think it's probably the longest CV that I've seen, and really a multitude of delights in terms of the articles that piqued the interest. But I'll simply mention just a few of her larger works. She produced a book in 2005, and this is Native Lordship in Medieval Scotland, the Earldoms of Strathairn and Lennox. And this won national prizes in Scotland and Canada, including from the Saltaire Society and the Society of Canadian Medievalists. She has since published a long list of article-length studies on various aspects of Scottish medieval law, as well as a further book in 2010, which is Land, Law and People in Medieval Scotland, Edinburgh University Press, and another work as well, also edited by Edinburgh University Press. She is a Fellow of the Royal Historical Society, a Fellow of the Society of Antiquaries of Scotland, and a Life Fellow of Clare Hall, University of Cambridge. And so we have, having had the opportunity to meet Professor Neville for the first time last night at dinner, also discovered an exceptionally lively intellect, as well as an astonishing appetite for travel, because when I politely inquired whether she knew Edinburgh well and might want some suggestions of places to see, I was very quickly put in my place, as it were, in the nicest way. She has been here on research visits 40 or 50 times, often spending significant amounts of time squeaking out that grant as best she could to extend her stay in working through the manuscripts that she was editing and analysing and so on. So I think we have really enriched by the lecture that we're going to have from a really keen, lively intellect, having travelled a great distance to bring this to us. And the subject of her talk is March Law as Old Law in the late medieval and early modern Scottish legal tradition. Professor Neville.
I thank you for that very kind introduction. I wish also to thank John Ford and all the members of the Council of the Stair Society for inviting me to give this lecture. It is a real honour, and it's perhaps particularly an honour for a Canadian to give this talk. A Canadian who's worked hard on Scottish history from a great distance for several years now. The text that is the subject of my lecture today, Leges Marchiarum, or Laws of the Marches, purports to record the findings of a formal inquest convened along the banks of the River Tweed in the spring of 1249 by a group of 12 Scottish and 12 English knights. Notable members of the landholding elite all, they assembled under the supervision of the sheriffs of Berwick, Edinburgh, Roxburgh and Northumberland, whose respective kings had set them the task of putting into writing the laws and customs that both groups claimed had traditionally governed the settlement of disputes in the border regions of either realm. The Leges Marchiarum treatise that grew out of that meeting is occasionally mentioned in passing in scholarly assessments of the growth of royal power and royal authority during the reign of Alexander II, and its early history was, a century and more ago, the subject of an important study by George Neilson. But with few exceptions, historians haven't devoted an awful lot of attention or discussion to it. And this is despite the fact that the treatise is extant in more than 20 late medieval and early modern manuscript Scottish law books. And, as I shall argue today, was clearly deemed by early modern jurists and lawyers alike a significant survival from the legal history of the medieval realm. There remain then many questions to be answered about the place of Leges Marchiarum among the fundamental changes to Scots law that underpinned the development of an independent kingdom of Scotland in the 13th century, but also about its continuing influence as an important witness to the past among later medieval and early modern men of law. Now, as some of you will know today, I've been working for some time now, very slowly in retirement, on an edition of the Leges Marchiarum treatise. And you'll hear me refer to that research project now and again during today's talk. The defeasance of Scottish claims to the three northern English counties of Northumberland, Cumberland, and Westmoreland, formalised in the Treaty of York of 1237, after a long history of Scottish efforts to control these territories, was soon followed by rival claims to jurisdiction over disputed title to lands located in that region, as well as over March offenders by Kings Alexander II of Scotland and Henry III of England. And I've put up just a wee list here in case you don't happen to know the reigns of some of the monarchs I'm talking about today. Within a decade of the Treaty of York of 1237, there were also complaints from the Scottish Crown that the ancient laws and customs of the Marches were no longer being observed. In an attempt to clarify the questions that had arisen from these claims, in the spring of the year 1249, an inquest of 12 Scots and 12 English knights, all named, came together at the command of their respective kings to determine which practices constituted these so-called ancient and approved customs, as both sides understood them, particularly the procedures to be employed in the punishment of offences committed by the subjects of one kingdom within the lands of the other. Collectively, the 24 knights agreed that any and all such offenders, and I quote, must not be impleaded other than at the march, end quote. That is, only at traditional sites that the rulers of both realms acknowledged as lying along the boundary line that marked one kingdom off from the other. The inquest identified as particularly troublesome acts of violence, ranging from theft to robbery to homicide, all of which required compensation of some sort. But the 24 recognitors also discussed the problem of fugitives who fled from one realm to the other, and ways in which debtors from one kingdom might be compelled to repay creditors from the other. The findings of the inquest of 1249, which run to several clauses in total, have often been referred to by historians as the first code of border law. It was not, in fact, any sort of code, but it did become the basis of a great deal of subsequent lawmaking in the Scottish borderlands. And within a generation of the meeting, the matters agreed in 1249 had acquired in Scotland the title of Leges Marchiarum inter Scotiam et Angliam. And it was under this rubric that the inquest findings, now in the guise of a treatise, first appeared in a law book dated to about 1270, circa 1270, in the so-called Berne Manuscript, one folio of which appears in the title of my lecture here today. And in later Scottish manuscripts as well, with the briefer title simply Leges Marchiarum. So in the remainder of today's lecture, for purposes of brevity, you'll often hear me refer to the treatise simply as LM. Simply easier to say than Leges Marchiarum over and over again. Now I want to begin my lecture today with a series of anecdotes, drawn not from the Scottish side of the border, but rather from the English. In a memorandum sent south around 1537, one of King Henry VIII's agents, possibly Lord Talboys of Redesdale, wrote in some frustration that justice was often, and I quote, deferred and not well exacted in March causes, chiefly because the laws of the marches between England and Scotland be uncertain, and a few or no books or other things in writing be remaining of record to prove these same laws." End quote. He recommended that this unhappy situation be remedied by drafting a document in which, and again I quote, "substantial known laws be put in writing, to remain in the warden or lieutenant's hands, which should give occasion of good justice to be had on the marches, and the many crafty delays now they are used in deferring of justice should be avoided." Now, this complainant was not alone in his uncertainty about the state of March law in England in his time. In the winter of 1541, as he prepared to meet ambassadors from Scotland, Cuthbert Radcliffe, who had been deputy warden of the Middle Marches for only about a year, wrote to Henry VIII's Privy Council, suggesting that someone other than himself, that understood the matters of the borderers better than he did, should be sent to replace him, ideally the lawyer Sir Robert Bowes. A year later, Edward Seymour, Earl of Hertford, about to demit his office as Chief Warden of the Scottish Marches, reported that before he departed the north, he considered it of first importance to, quote, "inquire and make note in writing of all laws, constitutions, and orders of the borders, and especially how the inhabitants of the same are bound by these." For he had found that matters concerning border law really tended to vary according to the whim of the parties involved. He assured the king that he would do his best to shoulder this challenging task, but might in the end have to leave the project to the Bishop of Durham, who I think by reason of his long experience knoweth most therein. The Earl's comments in turn prompted his subordinate, Sir William Ure, to undertake an immediate search in which he sought up such books and constitutions as have been made and established in these parts since my first coming, and which Ure duly sent on to Hertford. Still later, in August 1543, the Duke of Suffolk found it necessary to write to the Privy Council from the north for advice about how precisely he should proceed in the matter of collecting ransoms from Scottish prisoners, for he could find nothing locally to instruct him in such matters. Despite efforts on the part of other northern experts, notably the lawyer-turned-warden Robert Bowes, who in 1551 produced a useful manual on the form and procedures to be used at days of truce, many years later another Wardenial servant was still scratching around Carlisle Castle on behalf of Elizabeth I's secretary, William Cecil, amongst a multitude of writings for such books of March law and border causes as remain with me. He sent along what he could locate, apparently some treaty texts dating from 1449 and 1587, as well as sundry other items. But he confessed that he could find nothing more than 2 confused tracts of treaties, with a few articles dating from the time of Edward VI. A year and more later, this hodgepodge of laws and other writings remained in Carlisle, yet to be sent south for examination and review. Enough then with the anecdotes. They demonstrate, I hope, that in England, the inquest of 1249 and the LM treatise that came out of it had by the 16th century sunk into obscurity in the collective memory of English men of law, justices, and the officials who acted on behalf of the king in the northern borderlands. This occurred for a number of reasons, none of which need concern us here, but chief among them must be counted wartime enmities, of course, between the two realms, as well as the determination of English common law justices to retain and exercise exclusive jurisdiction over all offences committed in the northern counties of the kingdom on behalf of their own king. The situation could not have been more different in Scotland. Here, by contrast, the Leges Marchiarum treatise was destined to enjoy a long and storied life. In many respects, the history of LM closely resembles that of another 14th century treatise, the Leges Marchiarum. Later medieval and early modern jurists saw in both works exemplars of old Scots law. And even as they recognized that neither was genuinely legislative in nature, nonetheless treated both as rare and valuable survivals from the early Scottish legal tradition. The laws of Malcolm Mackenzie, too, despite being of dubious antiquity, and as the late Archie Duncan acerbically noted, little practical value, was prized as an authentic witness to the Scottish legal past, and for this reason was repeatedly included in late medieval and early modern compilations of law. The respect accorded the Leges Marchiarum of 1249 was even greater. Accordingly, as its more than 20 extant manuscript witnesses attest, Scottish lawmen of the 14th, 15th, and 16th centuries copied the little treatise over and over again into legal digests intended for study and circulation among jurists, notaries, practicing lawyers, and students of the law. Their 19th century descendants inherited a profound respect for the antiquity of the text. Like those earlier jurists, they considered it genuine material of the 13th century. The sheer number of medieval and early modern manuscript law books containing the text of the LM treatise only enhanced its value to these scholars as a trustworthy witness to a little-known period in the development of Scottish kingship generally and of Scots law in particular. Accordingly, LM appeared prominently in the first volume of the Acts of the Parliaments of Scotland, published in 1844. Cosmo Innes, one of the two editors of that volume, appended the treatise in Latin and Scots versions to legislative records firmly attributable to the reign of Alexander II. Now, as it happens, there are several problems associated with the edition of LM found in Volume 1 of the Acts of the Parliaments of Scotland, an exploration of which forms part of the more comprehensive study I have undertaken. But it's worth emphasizing here that in treating LM as a quasi-legislative treatise, and in linking it specifically with Alexander II, Innes endorsed the opinions of many of his medieval and early modern predecessors about the importance of the text in the context of the earliest legal writings from the Kingdom of the Scots. After the sealing of the Treaty of York, 1237, Alexander II will have been particularly keen on promoting a formal record of customary legal practices in the newly defined border region. His reign marked both the culmination of a key period of change, which saw the growth and maturation of legal, administrative, and financial institutions within Scotland, all of which would endure well into the early modern period, and of greater significance still, the articulation of new claims to superior royal jurisdiction over matters relating to the law. If the LM treatise was indeed what its compilers had claimed, a clear statement of customs that both crowns had inviolably observed since time immemorial, and these words I quote from the treatise itself, the King of Scots must also have relished having to hand a written agreement that he might deploy in future, not only when disputes and disagreements arose, and these were legion from the early 14th century onwards, but in the broader context of the ever-present spectre of English claims to overlordship of Scotland. Alexander II put such stock in the findings of the 1249 meeting that he ordered a copy of the inquest carefully stowed away. A 1292 inventory of the royal muniments stored in the treasury of Edinburgh Castle includes mention of a leather bag containing no fewer than 40 little rolls, schedules, and memoranda, together with other documents touching business related to the marches, including one item described as the record of a certain inquest regarding the marches. This last may well have been a copy of the inquest of 1249, which unequivocally acknowledged the King of Scots' jurisdiction throughout the southern borderlands of his realm. Irrespective of whether or not a copy of the inquest of 1249 was among the documents so carefully inventoried, there is little doubt that in the closing years of the 13th century, the Kings of Scots were already maintaining an archive of their negotiations with England in matters touching on the border region. The several clauses of what became the LM Treatise were almost certainly initially drafted in abbreviated or note form, as was typical of other inquests from the period, Scottish and English. Brieves, known in England, of course, as writs, that initiated royal inquiries, posed a series of questions which the assembled recognitors supposedly had the knowledge to answer with some confidence. There's little reason to suspect that the meeting of April 1249 did not unfold in this manner. The structure and the wording of the LM text, of the several clauses of the LM text, suggests that there were indeed responses proffered to specific questions and opinions offered as to customary or supposedly customary procedures. Thus, almost all of the several substantive sections of the LM text begin with the recognitors dutifully stating, they say that if it should happen that, and then this is what would happen. Or they say that if anyone commits this or that offense, and so on. So clearly they're answering questions that are being posed to them. When consensus on each of the matters under discussion was reached, it will have been recorded in writing. Only after the meeting of April 1249 had concluded and the recognitors dispersed were the findings of the inquest redacted into a more coherent form, that is the LM Treatise. How much later this occurred, and unfortunately by whom, cannot be known for certain. But there are some clues about how this process may have played out, and these are in turn, I think, borne out by later medieval recensions of the text. There were almost certainly two, and probably more versions of the findings of the border inquest created, with one perhaps intended for the Sheriff of Northumberland, who had represented the English crown at the meeting of 1249, and whose office was most likely to be among the first responsible for responding to any Scottish incursions, any Scottish violations of the recently agreed terms. A second copy of the inquest findings will have been intended for the Scottish side, whose king had sent the sheriffs of Berwick, Roxburgh, and Edinburgh to represent him at the border meeting. In fact, it seems more than likely that more than one copy of the inquest findings circulated in Scotland, for it would have been cautious to ensure that each of the three sheriffs secured one for himself. Later medieval versions of the LM Treatise suggest that some later instantiations of the text are derived from a treatise, or perhaps treatises, created very soon after the border meeting of April 1249. What happened to these putative early drafts of the LM Treatise in the years immediately after the conclusion of the commission of that year is simply not known. Alexander II's untimely death at Carrara in July of that same year left the matters agreed at the border meeting in something of a limbo, and the creation of a comprehensive text of the LM Treatise, perhaps a task yet to be completed. But complete the task someone did, for in the late 1260s or very early 1270s, a copy of the meeting notes, or of an early and now lost original compilation of these notes into treatise form, was available to a scribe who included the text, together with several other important legal materials relating to both Scotland and England, into what later became known as the Berne Manuscript. Sometime before September 1282, this or another manuscript of the LM Treatise was deposited into the treasury at Edinburgh Castle at the command of King Alexander III, where it was noted among a series of documents relating to negotiations with England. It seems likely, moreover, that it was a document styled simply Leges Marchiarum that, together with an inquisition labelled Tangente Marchiae, were itemized again in 1292, after the conclusion of the Great Cause, and described as among record materials scheduled to be handed over to the newly appointed King John Balliol. Now, the Berne manuscript needs little introduction among Scottish historians and even less introduction amongst Scottish legal historians. In its current form, it's a small law book containing selections of English law, to which have been added some important early Scottish materials. Its 63-odd folios were all written in a single hand, and eventually in the 19th century bound into a book. The late Lord Cooper suggested it was a kind of reference work for a lawyer in the employ of the Balliol family. William Scott has associated it more plausibly with the family of the Earls of Dunbar. Both agree that the manuscript is of northern provenance, and it was probably once in the possession of Kelso Abbey. That the oldest extant version of the LM treatise, as found in the Berne manuscript, may be the work of a Scottish author specifically, however, is suggested by the fact that this version alone, among the more than 20 that survive, lists the names of the Scottish sheriffs and the Scottish recognitors first, with the names of the English knights following immediately thereafter. All later versions, where these do not omit altogether the names of the recognitors, identify the English knights first, and then the Scots. Moreover, alone among the several early legal materials, English and Scottish, that make up the Berne manuscript, the LM text is decorated with a series of careful and elaborate manicules in green ink, which I've pointed out to you here, suggesting that this tract, and perhaps the specific passages to which the manicules point, may have been of especial interest to the writer. The spelling of Scottish family names and place names in the Berne LM too is consistent with that found in other contemporary documents originating in southern Scotland. There is other evidence of specifically southern Scottish authorship. The language of the LM treatise demonstrates a familiarity with terms that long before the 13th century had distinguished North Country English, which of course was the language spoken in Lothian, from those found in the southern heartland, even among legal writers. It has been noted, for example, that the Latin term villanus is only seldom used in charters from southern Scotland, with scribes preferring the alternatives bondus, rusticus, or nativus. The LM compiler used the last term exclusively, and he was clearly comfortable with other local linguistic peculiarities of the border region. Thus, while he was content to use well-known Latin forms of the verb namare, ironically itself derived from Old Norse, to describe the taking of goods as security, known as poins, he knew also to make a distinction between the oft-used Latin noun plegium, meaning surety or pledge, which appears regularly in the text, and an older term used to designate the special kinds of sureties or pledges who had power to distrain on both sides of the border in cases of debt. And in the LM treatise, the terms inborg and uteborg are found in two of the LM clauses, two words that are found nowhere else in Latin record. Whether or not the compiler was a Scot, that is, a man in the allegiance of the Scottish crown, or an English lawyer able to move easily across and to practice on both sides of the border, as Hector McQueen has suggested, cannot be determined, but is not wholly relevant. That the scribe knew a great deal about the nature of and the background to Scots law in the reign of King Alexander III is more certain. A notable example here is the mention in the earliest LM text of assignees, that is, procedures relating to the lawful non-appearance of an appeller or a respondent in court. In the mid-13th century, the term was well known among English lawyers. Essoines, as they were known in England, received extensive treatment in the late 12th century treatise on English law known as Glanville, and they were the subject of very, very recent legislation in the Statute of Marlborough of 1267, a copy of which, incidentally, also appears in this same Berne manuscript. Essoines are also mentioned in the earliest extant witnesses of the Leges Marchiarum, the laws of the boroughs, which also appear in the Berne manuscript. But the term Essoines is not otherwise found in Scotland until well into the 14th century, when it was made the subject of extensive discussion in Regiam Majestatem and what I might call its baronial equivalent, Quoniam Tachiamenta. The LM treatise then confirms Scottish familiarity with Essoines, if not in 1249, then at least by the time this manuscript is produced around 1270. Demonstrating in addition a clear understanding of the pragmatic difficulties that attended the settlement of disputes involving litigants from the vast area that was the borderlands. Equally important, LM adds to the substance of the nascent Scots law on licit excuses for non-appearance in court a novel, and as it transpires, a unique statement that in the border region at least, no man may assoin himself through death. And what that meant is people who were accused of an offense, even if they were dead, were hauled up to court and held up, and you could not assoin yourself through death. There are examples of that too. That the Berne LM was compiled by a lawyer thoroughly au courant with the changes that had been made to Scots law in the previous half-century is exemplified in another passage that governs the pursuit of fugitive naefs, or serfs. This echoes the wording of an act of Alexander II dated 1230, but not yet the changes that Alice Taylor has argued had been effected in the use of the term by the 14th century. Similarly, the Berne compiler's familiarity with the 13th century terminology used to describe a free or semi-free person, homologius, manens, nativus, suggests a writer closely in touch with contemporary discussions about the jurisdiction of king and lords over persons of low status. Collectively, these passages suggest a compiler who was able to interpret the several clauses of the LM treatise in light of contemporary Scottish legal norms. In England, the clauses of the Agreement of 1249 proved problematic to royal justices in eyre and were abandoned altogether after 1296, when the outbreak of war initiated the development of a body of border law that eventually operated alongside, if sometimes in competition with, the common law of the kingdom. Within just a couple of years of the sealing of a peace agreement between Edward I and Robert Bruce in 1328, Cumberland jurors were complaining that lack of a clear understanding of March conditions on the part of the King's justices in the north meant that acts of cross-border violence were going unpunished. As this complaint intimates, the stuff of this new and constantly evolving body of medieval March law already bore little resemblance to the testimony of the recognitors of 1249. Among the wardens, civilian lawyers, and conservators of the truce, who in the 14th and 15th centuries forged a distinct system of border law on behalf of the English crown, all memory of the text of the old Leges Marchiarum treatise was forgotten, not to resurface until Tudor-era antiquarians resurrected it as a relic of a bygone day. No such despair attended medieval and early modern Scottish lawmen interested in the legal history of their own border lands. For LM's 13th century origins, laid out so clearly in the treatise, were by now well known to them. Many of the early modern jurists involved in efforts to understand the old laws of the kingdom found in the LM treatise a witness to a long tradition of border legal customs. A written text that attested and indeed affirmed and authenticated the existence of such customs. Now, to be sure, the LM treatise never enjoyed the status that the much larger digests Regium Majestatem and Quoniam Attachimenta did. One reason why it hasn't really been looked at very closely. But it was close enough in time and place to these and other authoritative compilations of Old Scots law to maintain a secure place in manuscript collections that circulated widely amongst judges, lawyers, notaries, students, and others interested in the legal past. The laws and customs of the Marches of Scotland likewise developed in the context of open warfare between the realms, and evidence of the elaboration of these laws and these procedures, as in England, is to be found in the texts of increasingly long truces agreed between the kingdoms. Over the course of the late 13th and early 14th centuries, officials acting on behalf of the Scottish Crown had begun to work out a series of procedures by which incidents of cross-border violence might be addressed and resolved. In 1366, David II undertook, if in frustratingly vague terms, to reform and amend all such incidents according to the law of the March. In a similar statement of good faith, dated 1384, his successor Robert II promised that all incidents of truce-breaking would be redressed as law of March will. Casual references such as this abound in the many indentures of truce sealed between the Scots and the English between 1328 and 1500, as well as in written reports, queries, and complaints sent to the Lords Auditors in Parliament and the Scottish Privy Council. But linking Scottish interpretations of these laws and customs to the LM treatise itself is something of a challenge in this period. There are dozens upon dozens of vague references in extant record materials to Scottish wardens promising to conduct days of truce according to and to punish transgressors of the laws of the Marches. Sometimes this body of rules and regulations is rendered as the laws of the borders, suggesting the continuing appeal in the March lands of a tradition of customary law appropriate to March conditions. Nevertheless, these varied references, and more generally the mass of record material relating to March-related matters, organizing royal embassies for peace, negotiations between wardens for ransoms of important prisoners, and all the wrangling that preceded the actual provision by either side of redress and compensation for wrongs done, all suggest that over this period, the Scottish kings and their advisors put a great deal of thought into the laws and customs of the Marches. The jurists and royal agents who made arrangements appropriate for the special conditions of the borderlands grasped fully the notion that the stuff of what they called March law changed over time, as successive indentures of truce and negotiations for peace laid down new rules and new procedures. This kind of thinking was given clear expression in 1500, for example, when George, Master of Angus, undertook to hold a day of March and to adjudicate disputes between the realms, quote, according to the truces and appointments, that is, the recent truce and appointments that had been recently agreed with England. But ironically, in a report to members of the Scottish Privy Council that he submitted on the same day, it was the old law of the Marches they had in mind when he described a recent trial convened before a traditional assize, and I quote, both of Scottishmen and Englishmen after the form of the constitution made thereupon. He was referring here to the tradition laid out clearly in the LM treatise that claims of cross-border violence must be examined only by a mixed assize of Scotsmen and Englishmen. Just a few years later, members of the three estates acknowledged that the duties of the Warden of the East and Middle Marches included the upholding of the law and custom of the border as this had been set out in a recent indenture of truce. But at the same time, they also upheld the warden's ability to champion the validity of the law and consuetude of the borders. Over the course of his personal rule, James V is known to have demonstrated a keen interest over the firm control of his marches. And during his reign, a subtle change becomes apparent in extant record materials relating to the laws of the march. The Crown and its legal advisors adopted new language in their discussions of march law, now often designating it collectively as the consuetude, or the old use of the borders. And I'll return to this point in just a moment. An important component of old border consuetude in the 16th century was the very geography of the marchlands. The line of the Anglo-Scottish border along the River Esk in the West March mattered, and mattered a lot, as revealed in the heated diplomacy concerning the so-called debatable land, the troubled relations between England and Scotland all the way down to 1552. But so too did the traditions agreed with the English about the ancient historical geography of the borderlands, agreed back in the 13th century. Thus, James's border agents and the lawmen who advised them mounted a vigorous defense of the traditional sites where border-related agreements, and especially days of truce, where the wardens exchanged bills of complaint, ought to take place. This topic had been a bone of contention between the Scots and the English ever since the sealing of the Treaty of York of 1237, and grievances on the part of the Scots and English, that the English were making efforts to alter these customary meeting sites to their advantage, had flared up dangerously during the reigns of Robert II and Robert III in the late 14th century. First identified in the LM treatise as the locus of the famous meeting of 1249, Edinburgh in particular remained throughout the period between the 13th and the late 16th centuries emblematic as the original and the most significant of the traditional meeting places for days of March, for days of truce in the East March. It is described in the mid-16th century by one official as the place accustomed to convene upon the marches. In the West March in 1535, the Scots claimed that the use and custom of time begone held that the moat of Liddell and its environs was, and traditionally had been, the chief meeting place for days of truce. Until 1552, they held that the much debated lands of Kirkandrews-on-Esk, hard by the little priory of Canonby in the debatable land, was also a customary meeting place. That Scottish jurists were increasingly aware of the weight of old 13th century custom in March-related matters is even more apparent in the adoption of new terminology to refer to the laws that govern the marches. A language subtly designed to underpin the importance of custom as the foundation of all march law. Despite the respect that local Scottish wardens accorded to new practices agreed in successive indentures of truce, allusions in the records of the Privy Council and after 1532 in those of the Court of Session to the laws of the marches begin to assume new forms. I've noted briefly already the description of local customs as the use of the borders or as consuetudes. The latter term is particularly intriguing in light of the increasingly robust discussions among men of law, jurists and parliamentarians about the relationship between consuetude, that is, customs found in digests, compilations and books of old law, and more recent statute law. In 1545, the Regent Arran and members of the Privy Council heard that Henry VIII's representative in the English marches was abusing the old law, ancient use and consuetude of the borders in his ruling on a matter of ransom taking. They defended the traditional arrangements described in the old customs of the marches as, and again I quote, consonant to all law, reason, equity, and justice. A sentence that will recall, for some of you at least, the principles enunciated in the earliest statutes establishing the College of Justice. In the early 1550s, another group of councillors declared that old custom and use betwixt the realms in times begone as the authority upon which all future complaints regarding cross-border disputes must be resolved. In the same period, discussions among officials and the King's councillors openly equate the laws and lovable costumes of the borders with notions of justice and reason. This language suggests a vivid interest on the part of some mid-century jurists in subjecting the old laws of the Marches to the same methods of study and scrutiny that other lawmen were now employing to understand other examples of Old Scots law. Regium Majestatem, perhaps most obviously, but also shorter tracts that purported to represent authentic legislation of the 12th and 13th century kings, treatises that Alice Taylor has studied very comprehensively and appeared in an earlier volume of the Stair Society. The sealing of a lengthy and elaborate agreement regarding border matters in 1563 ushered in further change in Scottish views of the old law of the Marches. One of the clauses of 1563 truce required that in order to avoid ongoing confusion about the peculiarities of border practices, henceforth, and again I quote, all and every one of the wardens of both the realms shall incorporate and join together in one book all the traditional sources of March law, with these to be read and published openly once a year across the region. This clause was perhaps reflective of a broader reform movement in the kingdom designed to clarify the ways in which the old laws of the kingdom might inform new legislation. But thereafter, Scottish jurists began referring with some confidence to the laws and the practice observed on the border. And in a lengthy discussion in Council in 1579, reveals that such books of practice were indeed compiled and did in fact circulate. Scottish jurists in turn looked to the authority of both practice and written law in these manuscript books as the basis for a new interpretation of March laws. The shifts apparent in the choice of language used to describe the old laws of the March over the course of the 15th and 16th centuries reflect a much wider preoccupation on the part of late medieval and early modern Scottish jurists in the relationship between the old laws as found in ancient texts and statute law as enacted in the three estates. Later medieval Scottish lawmen preserved, copied, bound into books, and disseminated the texts of all the kingdom's old laws in compilations attributed to 12th, 13th, and 14th century rulers. Their enthusiasm for old works, even those that were plainly obsolete, was emblematic of a broader judicial and intellectual movement, the aims of which were both to understand the place of old Scottish textual sources in the making of the realm's legal history, and to reconcile these texts, sometimes formally referred to as the municipal law, with the Roman and canon law traditions of the universities and the Jus Commune. Recent scholarship has devoted close attention to this interest on the part of 15th and 16th century jurists in the legal past of the Scottish realm. It has framed several commissions aimed at reforming the laws of Scotland, one initiated in 1426, another in 1450, two more attempted in 1469 and 1473, and then a renewed effort launched in the 1560s as a conflict between a profound respect on the part of lawmen for the texts of the distant medieval past and the authority of statute law enacted by the king or queen and councillors in Parliament. To many of these lawmen, David Fergus has argued, the texts of the old laws were viewed as something apart, as something belonging to and handed down as part of the legacy of an earlier age. But as Julian Goodare, Andrew Simpson, Hector McQueen, and several other scholars have also shown, there was little sense that the old laws of the realm should be wholly superseded by new statute law. The jurists' veneration of the old laws as a body of learning, legitimately sanctioned by immemorial tradition, was in this sense a vital aspect of an ongoing discussion amongst early modern legal humanists in Scotland about the nature of legal authority itself, a topic that has also been the subject of a great deal of scholarly discussion and debate. But that such debates might involve specific questions of March law is shown in John Sinclair's Practics, a collection of notes and judicial decisions made in the Court of Session between 1540 and 1549. On one occasion, in a plea regarding payment of surety for an English prisoner, the defender relied on canon law to advance his argument, only to have the Lords of Council counter by citing a variety of Roman authorities that upheld the custom laid out in the treatise of 1249. Another case involving the allegedly unlawful release of an English prisoner turned on the citing of several Roman authorities, but the Lords also took into account the peculiarities of the laws of the borderers. Discussions amongst 16th century lawmen about the old laws of the Marches, their influence on practice at days of March, and their place within the jus commune of the realm all presupposed the ready availability of copies of the LM treatise. Gero Dolezalac has commented on the existence of a very considerable body of what he calls literature concomitant to 16th century lawmen's efforts to connect the learned law of the European universities to domestic custom and legislation. Adeline Wilson, Andrew Simpson, and perhaps most famously John Ford have all written at length about the importance of this literature, almost none of it printed until the 17th century, to an understanding of the relationship between the authority of learned law and that of native Scottish legal sources. The contents of the many digests, treatises, and compendia of old law differed, sometimes amended or altered according to their creators' readings, preoccupations, or basic Latin skills. Whether produced by agents working in the borderlands who required a dependable reference for matters relating to March law, by students who copied out short legal tracts as they trained to become notaries or lawyers, or as a consequence of calls for the reform of the law in Parliament. The 16th century saw the production of a very significant amount of legal literature in manuscript form, including multiple copies of the 13th century Leges Marchiarum. Well over half the extant manuscript versions of LM that I've been looking at in my research project date from the second half of the 16th century. The obsolescence of some of the clauses of the LM treatise will have been absolutely obvious to medieval and early modern jurists, but its standing as an authentic and unambiguously dated witness to the origins of the laws of the Marches under Alexander II ensured that it would not be quickly forgotten. Alice Taylor has made a persuasive argument for seeing in the so-called Moneynet manuscript of 1488 a carefully crafted book of royal law, produced by the men commissioned in 1469 to reform the laws of the kingdom. Irene O'Brien's study of the manuscripts of parliamentary legislation in the same period has likewise associated several compilations of Scottish legal materials from the 15th century with the reform effort. Moreover, several of the manuscripts that Adeline Wilson, Andrew Simpson, and others have claimed as the sources of the lawyerly discussions in the 16th century, particularly in the 1560s and 70s, include recensions of LM, And I have here a bunch of really, really boring overhead pictures to show you. What I mostly want you to see is, first of all, the number of manuscripts that you see here in which LM appears as a distinctive text, almost always with its own title set apart. That the treatise should appear in so many of these digests of foundational law, and foundational law as regarded by the 16th century itself, reveals that throughout a notable period of legal reform in Scotland, and one of frequent discussion about the nature of the kingdom's jus commune, jurists continued to accord considerable weight to the testimony of the treatise. With some notable exceptions, little change had been effected to the contents of the LM treatise when it resurfaced in the closing years of the 14th century in two comprehensive digests of law, the so-called Bute and Harvard manuscripts. Both were probably produced in the active and productive period of legal reform initiated in the late 14th century, following the return of David II from long captivity in England, and particularly serious clashes between David's Scottish successors and the English crown. Each of these two LM texts in turn, the Bute and the Harvard manuscripts, complete with the small but significant errors of transcription that distinguish them, became exemplars for all but one of the successive 15th and 16th century instantiations of the text, or at least the Latin ones. The exception here is a text currently housed in London, British Library, Additional Manuscript 18111, a text that has long interested scholars. When its two codicological sections were bound together around 1460, the newly created book brought together the texts of the most significant of the old laws then known to jurists. Roderick Lisle attributed the production of the two manuscript portions of the script of the text to the scriptorium of Dunfermline Abbey, and assigned the hand of the section in which LM appears to the middle years of the 15th century. The newly bound book was designed to represent a comprehensive collection of Scots law, and was almost certainly intended for circulation, copying, and commentary. Recent research has confirmed that despite its later 15th century date, the manuscript book preserves the earliest surviving versions of the two great legal digests of the 14th century, Regiam Majestatem and Quoniam Attachimenta, as well as early versions of some other medieval legal materials. These findings hold true also for the LM text. The British Library Law Book contains a version of the treatise closest in content, orthography, and spelling to the oldest extant witness of the Latin text of LM, that of the Berne manuscript. It may well have constituted a lost early version of the LM treatise, resurrected when Parliament required that the old laws of the realm be reformed. But my point here is that, like the better known Regiam Majestatem, the LM treatise was copied many times over and carefully bound together with other authentic old treatises into law books that were intended for wide circulation. More relevant still to the argument that LM was regarded and subsequently retained its reputation as authentic old law are the materials with which it became associated in its post-1270 manifestations. In the 15th and 16th centuries, LM was frequently included in law books that contained what were then believed to be traditional Scottish legal materials. Notably, the 12th century treatise known as Leges Scotiae, law codes attributed to Kings William I and Alexander II, and a treatise on the laws of the sea. And again, sort of overhead picture that students used to hate because it's nothing but words. What I want you to notice is the marks I've made here, the manuscripts in which LM appears with these other authentic old treatises and with Regiam. In some manuscripts, moreover, LM is placed directly after the so-called Statutes of Alexander II, associating it by proximity, if not strictly by definition, with specific acts of royal legislation of the mid-13th century. Other law books insert LM not directly after the legislation of Alexander II, but following the several statutes enacted by, or at least attributed to, other early kings of Scots, celebrated by early modern jurists as lawmakers or law reformers, once again associating the treatise by notional proximity, if not by precise date, with royal legislation. Several of the 15th and 16th century manuscript recensions, moreover, make that same connection even more explicit by designating the clauses of the treatise as the statutes of the 24, referring to the 24 men who originally gathered in 1249. From the mid-15th century on, additional materials relating to the legal system of the marchlands were drafted, and in later 15th and 16th century law books were appended to the LM text. And these included a collection of border-related ordinances set down in writing by the 8th Earl of Douglas in 1448, and a very short little treatise that describes the offences justiciable in the warden's court, datable to a period not much later than 1448. But to repeat, the reputation of LM as an important and authentic legacy of Scotland's legal and perhaps legislative past remains so high that few of the lawmen who studied it felt it necessary to alter the core of the original Latin text. That respect for the ancient origins of the LM treatise greatly outweighed its specific provisions is especially apparent in the status of some of the manuscript law books in which LM appears, and again its placement within those compilations. In this sense, more intriguing still are those manuscripts that repeatedly brought together the LM treatise, the law codes attributed to Kings David I, William and Alexander II on the one hand, and copies, whole or partial, of Regiam Majestatem on the other. So as this slide shows, the LM treatise in fact appears without Regiam in only a tiny handful of manuscripts. Regiam, of course, was regarded throughout the later Middle Ages as the single most important digest of early Scots law. That the LM treatise remained a living influence on the legal culture of late medieval Scotland is apparent finally in efforts to translate the work into the vernacular. There are 4 older Scots manuscripts included in the edition I'm working on, all datable to the middle to later 16th century. By this period, the Scots language was in regular use in Parliament, in the borough and baronial courts of the kingdom, as well as in the Court of Session. It was, moreover, in the many law courts of the kingdom that students, notaries, and pleaders received their initial training, and books of law written in Scots reached a much broader audience of law students and legal practitioners than Latin texts would have. Plus ça change, plus c'est la même chose. Little has been written about the distinctive nature of vernacular law books in late medieval Scotland, but one scholar's observation that the older texts of Regiam seem to have been stripped back versions of the original text is true of 3 of the 4 extant vernacular texts or versions of LM. All 4 demonstrate a determined, if paradoxical effort to update the treatise, in part as a reflection of the growing popularity of the everyday language in legal affairs, particularly in the setting of the marchlands, but also to ensure the use of accurate vernacular terminology amongst legal specialists. The compilers of the Scots versions sought to produce good translations of the core material of the older Latin text, if sometimes with dubious results. Each translates the original title of Leges Marchiarum, a title that itself had not really come into regular use until the 14th century, directly into older Scots as the laws of the Marches. In an effort to make ancient texts of practical value for the purpose of study and commentary, however, these newer versions discarded information that their authors considered irrelevant. First to go were the names of the 12 Scottish and 12 English recognitors who were said to have gathered in 1249, now long past being familiar as members of the cross-border aristocracy, and certainly no longer of any probative value. These are replaced in the Scots texts with more succinct references to 24 sworn men. The clauses that in the Latin texts hint at the liability of religious men to undergo trial by combat in cases of theft, robbery, or homicide, a practice, of course, that 13th century clerics had bitterly denounced, are faithfully retained in the translations. But anyone studying these manuscripts would most certainly have understood this concept as a relic of the very distant past. All but one of the vernacular texts abandoned altogether 2 entire clauses of the Latin version. The collection of cross-border debts was no longer envisaged as the relatively simple matter of business that had first been agreed in the 13th century and described in Clause 12 of the LM Treatise. Agreements involving the loan of money and foodstuffs must have been deeply disrupted by the wars of the later medieval period, and by the 16th century, any remaining concerns of this nature had long become matters for negotiation between royal embassies or locally between wardens of the marches on either side. Likewise, the system of cross-border sureties identified in the 13th century LM text as inborg and uteborg, although long obsolete, made the transition from the Latin into the vernacular March laws, although the spelling of these terms has changed almost beyond recognition, as have references to the long-defunct form of surety that appeared in the 13th century text as hand warsel. The fine owed for the slaying of a man, which appears as manbote, or a variation of that term in the Latin texts, has become the much more mundane silver in the vernacular texts. Older references to man-killing in the Latin texts have been updated to the more current manslaughter of the 16th century. And the varieties of terms associated with unfree persons in the 13th century manuscript have been collapsed into the much more generic term bondman. Like their Latin language counterparts then, the vernacular texts of LM were understood as books of law, intended for study by jurists and students of the legal past, rather than primarily as manuals for practicing lawyers. Nevertheless, the venerable reputation of the LM Treatise as authentic old law enabled it to make a seamless transition from Latin into the vernacular, and to open up its contents to a wide variety, or to a wide array of interested students and scholars. To jurists of the 16th century, the fact that the LM Treatise, in Latin or in Scots, might be outdated was of little importance when weighed against the valuable insight that the treatise offered into the distant legal past. And there were many such men of law, both at court and toiling in the many shrieval and baronial courtrooms of the border region. I've noted already that in the 1540s, Sinclair's practics discussed cases, the outcome of which depended on the application of legal principles customary in the borderlands. A little later, the scholar David Chalmers of Ormond included a handful of passages from the wartime ordinances of 1448 in an extensive compendium of Scots law that he dedicated to Queen Mary in 1566. Sir James Balfour of Pittendrigh thought the clauses of that same Douglas document of 1448 important enough witnesses to past border practice that he included the full text of the statutes among other legislation related to the Scottish marches in his own practice. A few years after Balfour's death, when another lawyer, Patrick or perhaps James Murray, set about recopying and rearranging Balfour's work, he added to the text a copy of the March Laws of 1249, clearly considering it still of historical value to a thorough discussion of border-related legal matters. A late copy of the LM Treatise, datable to the 1590s, is prefaced by a clear statement on the part of its scribe that the laws of the marches are, and I quote, made and established upon 3 special grounds: the jus gentium, which ruleth all, written agreements between sovereign princes, but above all on the customs generally used on the borders. End quote. That the relationship between old custom and written law was more than just an intellectual exercise, moreover, is apparent in a letter that Robert Bowes, one of Elizabeth I's most experienced border agents, wrote to William Cecil Lord Burleigh in 1593. At issue was an important point of law concerning the payment of appropriate redress and compensation for violations of the truce. The problem was with the Scottish claim that in some instances at least, and this was one of them, custom must be allowed to override the terms of the written treatise, the terms of the written treaties. Interest in the tracts and treaties associated with ancient border custom, moreover, was not confined to the busy law courts of Edinburgh. The earliest vernacular version of LM is found in a book of legal materials that includes the major digests Quoniam Regiam Majestatem and Quoniam Attachamenta. This compilation was created by the notary Robert Ewan while a student at St Andrews University before it was taken to Edinburgh. Eventually it found a permanent home in a private library of the Hume family at Manderston. Another vernacular version of the LM treatise was written for and used extensively by 2 Inverness notaries, William Cumming and Gilbert Duff. Both were town clerks, and both were active in the legal affairs of their community. Men like these were part of a profound transformation in Scottish society that Roger Mason has dubbed the laicization of Scottish society, in which education in fundamental legal skills, amongst other matters, opened up opportunities for middling sorts of landholders to compete for office and political positions once reserved to the wealthiest noble and clerical elite. They achieved such office in part by diligently studying and copying digests of old law, and by copying even something like the LM, which must have had very little application in Inverness. The intellectual ferment of the 15th and 16th centuries explains the enduring appeal of the LM treatise, despite the obsolescence of its contents. We can, I think, accept the premise that a lawyer in the employ of the Balliol family or the Earls of Dunbar copied into the law book that later became known as the Berne Manuscript the text of a border agreement that represented more or less accurately the customs that obtained in the Anglo-Scottish marches of his time, of the 13th century. We must also, however, acknowledge that after 1296, wartime conditions rendered almost all of the provisions of 1249 absolutely unworkable. We're left then with the problem of explaining why Scottish jurists maintained such a keen interest in this legal relic as they obviously did. Situating the manuscript edition of the little treatise known as the Leges Marchiarum firmly within the wider intellectual world of late medieval and early modern juridical thought in Scotland goes some way, I think, towards explaining the startlingly long life of this treatise. As I hope to have shown you today, it also shows why a new study of the lives of the LM manuscript is well worth undertaking. Thank you for your attention.
Thank you indeed. That comes to the microphone. Thank you very much indeed. That was